hello to all my dear foundation students. I hope your exams had gone pretty well. And today we are here to discuss the paper and to see how you have done, what you have done, and how it actually should have been. So we'll just, without much ado, we'll just get into the paper. So, yes, comparatively, the paper was quite easier than what we had seen in the month of September. So, and also a little less lengthier comparatively. There were a lot of direct questions also as compared to the September paper. So anyway, I'm just hoping that your paper had gone pretty well. And as we were just as saying, coming back to the discussion of the paper, question number one, which was a compulsory question. So the first question from Indian Contract Act: Mrs. Priya pays a sum of 10,000 to a marriage bureau to provide information about the prospective grooms. Now, marriage brokerage contract says that if I get the marriage of two people done and I ask money for that, that is void. But here she's only asking the marriage bureau to give her information to for prospective grooms. So asking for information from prospective grooms from the marriage bureau is not against public policy. So this contract is absolutely valid. Bharat agrees with Joan to sell his white bull. Unknown to both the parties, the bull was dead at the time of agreement. So the bull was dead even when the contract was made. So can I say this is bilateral mistake about existence of subject matter? Yes. Can I also call it as impossibility existing at the time of contract? Yes. Can I say it is void ab initio? Correct. Rishabh sells the goodwill of his shop to Omkar for 10 lakh and promises not to carry such similar business within the local limits, not to carry similar business within the local limits so long as Omkar carries on the like business. Okay, so basically here the goodwill of the business is sold and the contract says that I will not carry the same business as that of the, for the goodwill that I have sold. Now, this is an agreement in restraint of trade. As far as agreement in restraint of trade goes, we know that if the terms are reasonable, it's valid. If the terms are not reasonable, it's not valid. Here, we are restricting him only from carrying the business in the local limits. So, because the restriction is limited, it is absolutely a valid restriction. So, this contract is valid. A property worth 2 lakh was agreed to be sold for just 25,000 by a person of an unsound mind. Since he's a person of an unsound mind, any contract. Now, here what you will think, 2 lakh property sold only for 25,000. Oh, this is coercion. No, there is nothing about crime here. So here they are saying the person was of an unsound mind. And since the person was of an unsound mind, the contract is what? Void ab initio, right? Harmony Foundation is a newly incorporated company focused on promoting education and healthcare services in rural areas. The company is registered as a Section 8 company with a clear plan to reinvest all profits into its activities. So, they have a clear plan that they are going to reinvest their profits that they earn in the activities to promote their activities, and a license has been accorded by the central government. They have already got the license of Section 8. For the financial year ending 31st March 24, the company earned a substantial profit and transferred some amount to Messrs. LMP Associates, a firm, one of the member of the Harmony Foundation. Okay, first of all, can a company actually transfer its profits to its members? No. And when the company transfers its profits to the members, it is nothing but transfer of your profit in the form of dividend, which is not allowed. So, in any way, if you are giving profits, you're not allowed to give profits. And it was very clearly given that we will reinvest all the profits. Right? It was given. That was the purpose, the objective. And anyway, if you are a Section 8 company, you cannot give your profit to your members. Subsequently, on the complaint of one of the members, the central government, after giving an opportunity of being heard, directed the company to be wound up on the ground that a partnership firm cannot be a member of the Section 8 company and it cannot transfer any part of the profit to the firm. Now, there are two things here. First of all, when a Section 8 company breaches its object, so we are going to write about two things here. When the Section 8 company breaches its objects, in that case, the central government can revoke the license. And when the license is revoked, three orders can be passed. Remember, winding up. company can be ordered for winding up for breaching its objects. And in that case, the central government must give an opportunity of being heard, and also in the public interest, it can wind up the company. So, winding up the company on the grounds that it cannot transfer any part of the profits to the firm, this is absolutely valid. As far as this is concerned, as far as this is concerned, that a firm cannot be a member of a Section 8 company. Well, Section 8 very clearly says generally in a company, a partnership firm cannot be a member. But once you have got a license under Section 8, even a partnership firm can be a member. So on this grounds, it is not valid. However, because the company has breached its object and given a part of the profits to the partnership firm, the central government has a right to wind up the company. Justice Private Limited has 9 directors on its board of directors. The company's articles of association currently state that the quorum for board meeting shall be 1/3 of the total strength of 2 directors or 2 directors, whichever is higher. The company now intends to amend this article to specify that the quorum for the board meeting shall be 1/3 of the total strength or 4 directors, whichever is higher. Now, you know what? Basically, what will happen, you will see directors, oh my God, board meeting I've not done. That is not even the question. Now comes the real question. Advise the company on the procedure for including this entrenchment provision in its articles in accordance with the provision of the Companies Act. They just want you to talk about entrenchment clause. And what would be your answer? Would your answer be different if it were a public company? So, as per Section 5 of the Companies Act, when we talk about entrenchment clause, means providing additional safeguards. A company's articles can be altered by passing a special resolution. However, company may specify in its articles that a particular clause can be altered only by provisions which are more restrictive than special resolution. And we can add this entrenchment clause either at the time of incorporation or as an amendment. If it is done as an amendment, then in case of, because it's a private company, consent of all the members would be needed. However, if it was a public company, we would need again special resolution for adding this amendment. So you just had to write about the entrenchment clause. A minor admitted to the benefits of a partnership firm is entitled to certain rights and may also have certain liabilities to third parties for the acts of the firm. Discuss the rights and liabilities of the minor before attaining majority under the Indian Partnership Act. So, what are the rights and liabilities of the minor? When a minor becomes a beneficiary, okay, when a minor becomes a beneficiary, he shall have a right to get his share of profits. He shall have a right to check, inspect, and copy the accounts of the firm. He shall also have a right to sue the other partners for his share, provided he severs all his connections with the firm. On attaining majority, he also has a right to decide whether he wants to leave the firm or join the firm. As far as liability is concerned, a minor, when he becomes a partner of the firm, he cannot have any personal liability. However, the liability is against his share in partnership. But yeah, before you start writing rights and liabilities, you should definitely give a 1 or 2 line explanation about the fact that a minor cannot become a partner. However, he can be admitted to the benefits. MNO Limited, a supplier of electronic components, entered into a contract on 1st August with PQR Enterprises for the sale of 1,000 units of microchips. The contract specifically identified the microchips by serial number and confirmed that they were in a deliverable state stored in MNO Limited's warehouse. Correct? That means what? That means, first of all, these are what? Specific goods, right? MNO was going to supply these components to PQR Enterprise, right? The contract specifically identified the microchips by serial numbers and confirmed that they were in a deliverable state. It is specific goods in a deliverable state stored in MNO Limited's warehouse. The contract stipulated that the goods would be delivered on September 1, 2023. On August 10, a flood occurred, damaged the warehouse, and destroyed the entire stock of microchips, including the 1,000 units intended for PQR Enterprises. Examine with reference to the provisions who shall suffer the loss. What would be your answer if the microchips are not specifically identified and marked for PQR? Okay. Since the goods are in a deliverable state, it is the duty of the buyer to take the delivery of the goods. And here it is also given that they were in a deliverable state and they were in his warehouse. So, because the goods are specific goods and they are in a deliverable state, nothing is given about ownership here. So, because when the goods, if you remember, we had done the same example about the 50 books where I couldn't take the delivery right now, I'll take the delivery later, right? So, when the goods are in a deliverable, specific goods in a deliverable state, ownership is transferred immediately. So, here ownership has already been transferred to PQR. So, on August 10, a flood occurred, damaged the warehouse, and destroyed the entire stock, including the 1,000 units intended for PQR enterprises. Examine with reference to the provisions of the Sale of Goods Act who shall suffer the loss. So, who shall suffer the loss here? Obviously, the ownership is already transferred to PQR. So, here, who will suffer the loss? PQR. For the 1,000 units, and for the rest of the goods, it will be suffered by MNO, right? Examine with reference to the provisions of the Sale of Goods Act who shall suffer the loss. Already done. What would be your answer if the microchip are not specifically identified and marked? If the chips are not specifically identified or marked, then the goods are not in a deliverable state. In that case, if the goods are not in a deliverable state, the ownership will not be transferred unless they are identified. So, in this case, the ownership is still with MNO. And in this case, who will bear the loss? Obviously, MNO will bear the loss. A purchases a motorcycle from B and uses it for some time. It turns out that it was stolen, it was a stolen one, right? Same example we had done, if you remember, in condition as to title. A sold a second hand scooter to B. So it turns out that the motorcycle sold by B to A. So B was selling here. A had purchased it. So B sold it to A. And this was stolen and had to be returned to the rightful owner. Can the rightful owner claim the goods back from A? Yes. A must return. Yes. A brings action against B for the return of price. Can A sue B for return of price? Yes. On what grounds? Condition as to title. When the seller has sold the, when the seller sells the goods, we imply that he has a right to sell the goods. And that is why he's making a contract to sell. If the seller has no rights to sell the goods and the buyer is deprived of the goods by the true owner, the buyer can claim the damages from the seller. I'm sorry, the price of the goods from the seller. Write in brief the content and model of the articles of association according to which the director and other officers are required to perform their functions as regard the management of the company, its accounts and audit. Okay, this is definitely not there in your book or anywhere. Now, this was about, if you remember, table FGHIJ gives us the format of the model of the articles of the model of the articles of the companies. From F, limited by shares, limited by guarantee with share capital, limited by guarantee without. So FGHIJ like that. This is honestly not even there in your book. Then they have never given the content also in your book. It's not there. So they're just, it's about the, the powers of the board, the powers of the directors, as in what functions they can do, what all they cannot do. It's about that. But it's actually not there in your book. It's not there. It's not there in your book. It's just they had given the table number. That's it. Diana and Bharti, newly qualified CA, wish to form a LLP to provide their professional services. They seek information about the provisions of the LLP Act, specifically regarding the incorporation document. So basically, they are talking about the procedures for incorporation. Additionally, they want to know whether the statement filed along with the incorporation document serves as sufficient evidence that all requirements of the incorporation have been fulfilled. So first of all, when it comes to incorporation document, the company has the LLP, the partners who want to form the LLP has to file this LLP document with the registrar, incorporation document with the registrar of the state where they wish to register. Minimum 2 persons have to sign it. And the incorporation document shall state it should be in the prescribed form. It should state the name of the LLP, the business of the LLP, the proposed business of the LLP, the address of the LLP, the name and address of the persons who are named as partners, the name and address of persons who are named as designated partners, and any other information as is required. So these all things have to be there in this document. And along with this document, we give a declaration which is filed by which is actually a declaration given by the professional, right? And a declaration which is given by the person who is named as as a partner, that is, who has subscribed to the incorporation document, that we have fulfilled the requirements of the act relating to incorporation. And yes, it acts as an evidence that we have fulfilled the requirements of the act for incorporation. And on this, the registrar will issue us a certificate of incorporation. Okay, the same question was there in our material. We have done the same question. PQ and R are partners in a construction firm. PQ are associates. P buys cement on behalf of the firm from D. The cement is used in the ordinary course of the firm's business. P uses the cement for his personal purpose. The supplier, okay, when the goods are ordered in the ordinary course of the business, right? And which shows that they are ordered for the firm. It is ordered in such a way that shows that it is ordered for the firm. Who is liable? Firm is liable. The supplier D, who is unaware of the private use, claims the price from the firm. Is the firm liable to pay? Yes. The firm refuses to pay for the price on the grounds that the cement was never received by it. Doesn't matter. Any act done by a partner in the ordinary course of the business and which shows that it is done on behalf of the firm is liable. Referring to the provisions, whether the firm's contention is tenable. No, the firm is liable. Yeah, it's a different story that they can recover it from P. But as far as the third party is concerned, who is liable? Firm. What would be your answer if a part of the cement so purchased by P was delivered to the firm and the rest of the cement was used for private use about which neither the firm nor the supplier were aware? Doesn't matter. The situation is still the same because it was ordered in the ordinary course of the business and shows that it was ordered on behalf of the firm. Irrespective of whether the firm used it or not, the firm remains liable. The extract of the major shareholders holding paid up capital in Rural Development Financial Corporation Limited are as follows. Central government 26%, state government, state of Maharashtra 18%, state of Tamil Nadu 24%, and public 32%. Whether the company would be considered as a PFI. Now, to be notified, so you have to be notified by the central government as a PFI, and you will be notified as a PFI if you fulfill any one of the two conditions. If you're formed under a special act, or 51% of your capital, share capital, is held by central government or state government or both of them put together. Here 26, 18, 24, which comes to 68% is held by central and state, then yes, it can be notified as a PFI. Explain in brief about the various institutions regarded as PFI. So LIC, IFDI, then Unit Trust of India, Units of Unit Trust of India, or any body corporate notified by the central government will be considered as a PFI. Whether it is mandatory to have a common seal for the company. Before 2015 it was, but in 2015 amendment, it was removed. No, a company may have a common seal. If not, what are the other options available? If the company does not have a common seal, the document shall be signed by 2 directors of the company, or it will be signed by 1 director and 1 company secretary if company has appointed a company secretary. And you know what? If company has appointed, secretary signature is there, has to be there. So it has to be signed by them. But if not appointed, then by any 2 directors of the company. What are the agreements which are held to be opposed to public policy under the Indian Contract Act? Explain any 6. They want you to explain trading with enemies. So we had like 10 of them. Trading with enemies, stifling prosecution, champerty and maintenance, interference with the course of justice, sale of public offices, agreement and restraint of marriage, agreement and restraint of trade or for the creation of monopoly, agreement and restraint of legal proceedings, and marriage brokerage contract. So you just have to write any 6 of them. ABC, okay, this question, same question, we have done it in the book, it is there. In our material, it is there. Even in the scanners, it's there. A, B, and C jointly promised to pay the sum of 6,000. Examine considering the provisions. Can D compel any of the 3 parties? Yes. In case of joint promisors, each of the joint promisor is jointly liable for his share and severally for the whole share and can be compelled by the promisee to pay the whole share. C is compelled to pay the whole amount to D. Can he recover anything from A and B when both A and B are solvent? Yes, he can recover from each of them their respective shares. Right? And their respective share is what? 1500, 1500? Is it 1500? It's 6000 divided. Oh, sorry, 6000, 2000, 2000 each he can recover. A is not in a position to pay anything. So if A is not in a position to pay anything, then in that case, each of them will pay their own share. That is, B and C will pay their own share plus the loss, right? Plus the loss of this B and C will pay 2000 each, which is their share. Plus A is not in a position to pay. So A's loss of 2000 shall be borne by B and C. Now, in what ratio would they bear it? It will be borne in their ratio, which is equal. So each of them is liable to pay 1000. That means now each of them is liable to pay 3000. So C can take from B 3000, 2000 his and 1000 A's contribution. What are the rules governing compensation payable in the event of dishonor of a negotiable instrument? So, in case of dishonor of a negotiable instrument, compensation payable is the amount of the instrument. Apart from that, you will also get interest at the rate of 18% from the date the amount was payable to the date the amount is actually paid per annum. On that, for that period, you will get interest. Apart from that, if he has incurred any expenses or cost, if the holder has incurred any expense or cost on that instrument, he can also claim that cost that he has incurred on the instrument. Also, if you are residing in any other place, then in that case, it will be done at the current rate of exchange on that day. Ashok and Vimal are pursuing CA course and discussing about the structure of the Indian judicial system. Explain them the functions of judiciary system and hierarchy. So you basically have to talk about Supreme Court, High Court, District Court, and Metropolitan Court, and you have to give their powers, who can pass what orders, all of those. The Institute of Science, Pune, placed an order for various chemicals worth 1,50,000 from a supplier in Delhi. The buyer made full advance payment and the seller dispatched the consignment via a courier of his own choice without reserving any rights of disposal over the goods. The consignment was lost in transit when he does not reserve the rights of disposal, right? And the goods have already been dispatched. The ownership is already transferred, right? The consignment was lost in transit and now the buyer seeks a refund of the purchase price. So can he actually claim for the refund of the purchase price? Okay, so since the seller has not reserved any rights of disposal, if he would have reserved the rights of disposal, the ownership would not have passed to the buyer. But since he has not reserved the rights of disposal, the ownership has already passed on to the buyer. So who will bear the loss? Buyer will bear the loss. So can the buyer claim the refund? No, the buyer cannot claim the refund. Adarsh visited an authorized car showroom and purchased the car of his choice without conducting a detailed inspection. After making the payment and taking delivery of the car, he discovered a defect in the engine that could not have been detected even with a reasonable inspection. That means what? It is a defect which is not visible to the eye, right? He purchased the car of his choice without conducting a detailed inspection. After making, and he discovered a defect in the engine, which puts a question as to the merchantability of the car. And it could not have been detected even with a reasonable inspection. So, with whether he can invoke, they have, and no, I did not even read the question. They have already talked about merchantability. Can he repudiate the contract? Yes, because it was something which was not visible. That means even if he would have done a detailed test, he could not have found it's a hidden defect. And because the goods have a hidden defect, he has a right to return the goods back on the grounds of defects as to the condition of merchantability. It was a hidden defect, cannot be found because of this line. Otherwise, could he have returned? No, because he never tested, but it could not be detected. So, on the grounds of merchantability, can he return the goods back? Yes. Explain the following under the Partnership Act. Partners by holding out. When a partner of a firm represents another person as a partner, even though he's not a partner and such person does not deny it, or when an outsider represents himself as a partner, even though he's not a partner, in that case, if the third party contracts with the firm, such person is liable. Nominal partner who lends his name to the firm because of his goodwill. He does not take part in the business or bring in capital. However, he is liable to the outsiders for the acts of the firm. Dissolution of a partnership firm may occur by mutual agreement with the consent of the majority of the persons, while compulsory dissolution requires an order from the court. Discuss the statement with reference to the relevant provisions of the Indian Partnership Act. Dissolution may occur by mutual agreement, right? With the consent of majority of the partners. This is wrong because I need the consent of all. Mutual agreement means all the partners have mutually decided to dissolve the firm. While compulsory dissolution requires an order, well, this is also wrong because there is not necessary that, like, for example, in case all the partners are dead or all except one, all the partners are dead or all the partners are insolvent. In that case, it is mandatory that you have to dissolve the firm. In that case, the partner, the remaining surviving partner, can dissolve the firm with even without the order of the court. However, if he does not dissolve the firm, continues the firm, then court may order for the dissolution. So this statement is wrong because when it is dissolution with the consent of majority is not allowed, because if it is a dissolution by choice, voluntary, even then I need the consent of all. And if it is a compulsory dissolution, there is no hard and fast rule that you have to get the order of the court. You can on your own decide to dissolve. However, if you don't dissolve, then the court may order. So you have to give the explanation to this point and conclude that this statement is not correct. Explain with reference to the Indian Contract Act when a contract is said to be induced by undue influence, where two parties stand in a relationship and one party has a dominating position which he uses to make a contract on terms which are unreasonable. The force is a mental or a moral force and can be by or on a third party. When a party is deemed to be dominating the will of another, to be in a position to dominate, if there is a real or apparent relationship, the same question was there even in our scanner also. If there is a real or apparent relationship, or if there is a fiduciary relationship, or if the person is under a mental distress, or if the terms are unconcisable or unreasonable. Anjali purchased various cosmetic products worth 15,000 during the last week from Sushil, a shopkeeper, on credit of 1 month. After a fortnight, she makes out a blank promissory note, signed it, and delivered it to Sushil. Blank promissory note, which is an incoherent instrument. Same example we had done in the class, just the figures were different. I think figures were also same, if I'm not wrong. She makes out a blank promissory note, signed it, and delivered to Sushil, who further endorsed it to Manish for payment of his dues. Okay, Manish was a holder in due course. Manish is a holder in due course. Filled the amount of 17,000 from Sushil. So Anjali gave it to Sushil with an authority of 15,000. Sushil had to pay his dues to Manish, so gave it with an authority of 17,000. And from Sushil, and on maturity presented it to Anjali for payment. But she refused to pay because the amount filled is more than the agreed amount. It is to be noted that the amount of 17,000 is covered by the stamp. So, in case of incoherent instrument, when a drawer gives an incoherent instrument, the payee can only fill it up to the extent of authority given. So if S had to recover, he could only recover to up to 15,000. However, if the instrument is endorsed to a holder in due course, the holder in due course has a right to recover up to the full extent of the value of the instrument. Here, it is given that it covers 17,000. So when Manish fills it up for 17,000, he has the instrument is covered for 17,000. Since Manish is a holder in due course, he has a right to recover to the full extent of the instrument. So, in case of incoherent instrument, the holder can only recover to the extent of authority given to him, but the holder in due course has a right to recover up to the full extent of the stamp value. So, can Anjali refuse? No, Anjali is liable to pay 17,000. Priya, a small business owner, receives a bill of exchange from her customer Sanjay, which is due for payment on October 15. On October 12th, Priya presents the bill of exchange for payment at it is due for payment on October 15. Right? The payment payment, it should be presented on 15th. On October 12th, Priya presents the bill of exchange for payment at Sanjay's office during regular business hours, but Sanjay is not present. Priya leaves the bill with Sanjay's assistant. Okay, if I present the instrument before, first of all, it should be presented on the maturity. Second, it's presented before time. Second, it was presented at the office, but the person was not there. So he left it with the assistant. Now, when the drawer is not available, I can give it to someone else on his behalf, but the person must be an authorized agent. Was the assistant the authorized agent? No. Requiring to be presented to Sanjay for payment when he returns. However, Sanjay's assistant forgot to give the bill and Sanjay does not make the payment and the bill is dishonored. Examine whether Priya's presentation of the bill is valid. No, it was made before time. And most importantly, it was not made to the authorized person. Here, the assistant was not the authorized person, so it's not a valid presentment. What are the conditions to be satisfied for an agent's authority in an emergency? So he must not be in a position to communicate. There must be a real necessity, and he must have acted as a man of ordinary prudence. Both sub-agent and substituted agent are appointed by the agent. However, there are some points of distinction. Sub-agent is appointed, both of them are appointed by the agent. However, sub-agent is appointed under the authority of the agent, whereas substituted agent is appointed under the authority of the principal, right? So a person has no agent has no right to appoint a sub-agent, but he has a right to appoint a substituted agent. Substituted agent is always appointed on the orders of the agent, whereas sub-agent is not appointed, can only when appointed on the order of the agent is valid. For the act of the sub-agent, the principal is not liable unless he has been properly appointed. For the act of the substituted agent, the principal is always liable. If the principal is liable for the act of the sub-agent, he can recover it from the agent. Right? If the sub-agent has done anything wrong, to the third party, principal is liable. But the principal can recover it from the agent. But for the act of the substituted agent, the principal is liable and he cannot recover it from the agent. Unless agent was negligent in appointing the substituted agent, right? A substituted agent can directly sue the principal, but sub-agent cannot directly sue the principal. What are the rights of a buyer when the seller commits a breach of contract? So, rights of the buyer, first of all, when the seller commits a breach of contract, if he does not deliver the goods, the buyer has a right to sue for damages for non-delivery of goods. Second, if the goods are antique or the goods have no substitute, or damages are not an adequate relief, the buyer has a right to sue him for the specific performance of the contract. Then, if there is a breach of condition, treated as a breach of warranty, or there is a breach of warranty, he has a right to sue for damages. Then, if there is a breach of condition, or he has paid advance money but the goods are not delivered, then he has, or if there is a breach of condition, then he has a right to ask for the refund of the money. So, with this, we are done with the discussion, and you have ample of time left before your results and before your inter preparation starts. Don't forget, you are doing CA, so you really do need to keep revising things which are common. And yes, do enjoy this period of time, because after you get into inter, you will be again too busy with your studies. So do what you wanted to do, read a book, watch a movie, do whatever you want. And hopefully we'll see you all as CA inter students. All the best to all of you for your results. Thank you so much.